Counsel Jack Smith's criminal indictment appeared to be more than 2.5 years in the making, but the American public heard many of the key details of this case outlined in a series of hearings last year, as well as in an 800-page report run by the January 6th Select Committee. As striking as it is, the 4-count indictment handed up by the grand jury hews closely to the roadmap outlined by the Select Committee in its final report. In fact, 3 of the 4 counts included in the special counsel's indictment mirror charges that were recommended by the panel. The committee also specifically recommended prosecution of Trump himself and one of the ex-president's now unindicted co-conspirators, attorney John Eastman, who still could face legal peril as the special counsel probe continues. Now, of course, the Justice Department could advance their investigation beyond what Congress had been able to accomplish, but still, this shows the 2 investigations, which each had different goals and tools, could collect evidence around Trump's post-election efforts and land roughly at the same conclusions. Congressman Jamie Raskin, a member of the Select Committee, said this about the indictment: many of the crucial facts that surfaced during the January 6th investigation reappear in this indictment. We told this story in time for these events not to be buried in ideology and deceit. It feels to me like a powerful vindication of the rule of law in America. Joining me now is Tim Heaphy, former lead investigator for the January 6th Select Committee. Tim, it's great to see you again. We've been speaking quite frequently, you and I, but I wanted to get your reaction to what has been happening between Trump, Jack Smith, and Judge Tanya Chutkan, who denied the Trump request for an extension to respond to the Justice Department's motion for a protective order. I mean, this morning, Trump attacked the judge, saying he wanted her recused from the case. The protective order was requested after he threatened, I guess generally made a threat against those that may be involved in the case on social media. And this kind of intimidation is common for Trump. We saw him make similar attacks on people who testified before your committee, including Cassidy Hutchinson and others. Do you believe a protective order against Trump is necessary as this case proceeds?
Yeah, I mean, I'll leave that to Judge Chutkan. She's very capable. I will say that what we found repeatedly over the course of our investigation are that the former president's tweets are not taken rhetorically by people in America, but are taken literally. We talked to dozens of people that came to Washington and ultimately ended up at the Capitol because of his specific invitation, because of his words. Because he personally identified Ruby Freeman and Shay Moss, the 2 election workers in Georgia, Al Schmidt, the election official in Philadelphia, they received direct threats. So what the president says, this is classic political speech. It actually has real life consequences in terms of the safety of people who are either directly or implicitly referenced. So it's very dangerous. I'm sure Judge Chutkan is going to want to hear a reasonable explanation from the Trump team before she rules.
Let me play for you committee member Zoe Lofgren speaking during a hearing with Ben Ginsburg, a lawyer who has represented Republicans in national elections.
So are you aware of any instance in which a court found the Trump campaign's fraud claims to be credible?
No, there was never that instance. In all the cases that were brought, and I've looked at the more than 60 that include more than 180 counts. And no, the simple fact is that the Trump campaign did not make its case.
Do you feel your work has been vindicated by this indictment?
I mean, look, I think Congressman Raskin, who you quoted earlier, is exactly right, that we were able to lay out the core facts that have now been included in this indictment. Right? Facts make cases, not lawyers. And we were only as good, the Select Committee was only as good as the facts we developed. It was pretty obvious to us early on in our investigation that there were a lot of pretty powerful facts here that demonstrated crimes and in specifically intended plan, multi-part plan to disrupt the joint session. So we did, I think, a very credible job laying out those facts. But to be clear, it's the facts which are so compelling. It isn't the January 6th committee, or even Jack Smith. Really, it's the cards that we had to play that are now been passed to him. I think he's added a few cards, likely has even strengthened that hand. But the facts here establish, beyond likely any reasonable doubt, that there were federal crimes committed.
You said he may have added some new cards, he may have added some new players. Could you talk to us about the involvement of players who refused to come before your committee, people like Mike Pence, Mark Meadows, your reaction to what seems to be critical evidence from them that helped build the criminal case against Donald Trump?
Yeah, I think it's clear from the indictment that, take Mike Pence for an example, he took contemporaneous notes of his conversations with President Trump. He provided a direct account of their conversations when only the two of them were present. We knew generally, the Select Committee knew generally what happened in those conversations, but it's really powerful to have a participant in the conversation recount it. I think Pat Cipollone has given some additional information that he stopped short of providing to us because of privilege. This is all because Jack Smith has the ability, because this is a criminal proceeding, to go immediately upstairs to the chief judge of the district court that is supervising the grand jury and get rulings on privilege issues. We did not have that ability. Congress does not have the same rules. Congressional oversight doesn't have the same rules as a criminal grand jury. And that's why, for us, it was civil litigation, which lawyers knew would not run its course before we expired. So he's using that power to get more information. And again, likely adding really important new details to the core story that we set forth.
In a broad sense, was there anything, I guess, that surprised you about the indictment? I mean, the information you didn't expect to see, for example, or perhaps this charge that we have talked about, this KKK charge that I don't believe was one of the recommended charges from the January 6th committee?
No, I can't say anything surprised me. There was a menu of statutes that could have been used. There were more facts beyond those included in the indictment that could have been included. The indictment was surgical. I think it was clearly intended to position the case to get adjudicated most quickly, a single defendant instead of the 7 who have criminal exposure as articulated in the indictment, and cases that are counts that have been really widely interpreted. Obstruction of official proceeding is the main vehicle that the Justice Department has been using in the blue-collar January 6th cases. So some of the other statutes are a little bit less clear in terms of the precedent and might have some free speech issues. So I'm not surprised at all. I think it was a calculated decision to try to get this case resolved as soon as possible.
Tim Heaphy, always a pleasure, sir. Thank you so much for your time and for joining us this evening.